Good afternoon, all the esteemed people on the dais, all the members of the faculty, and all the students of this university. I am very happy in particular to see that there are so many girls here. I think the girls outnumber the men by 4:1 probably. And that's a good sign that girls are today more interested in current issues of importance. So, Professor told you that there are two kinds of federalism coming together where, like the European Union, where you have a large number of sovereign countries which come together to form some kind of federation by which the Central Union, that is the European Union, will be given some powers. And of course, each state says that we are sovereign within ourselves, but certain things we will allow the European Union to do. United Nations was also supposed to be one of the coming together type of federations, but unfortunately United Nations was hardly given any powers or any teeth, especially because in the Security Council you had 5 countries who were given veto powers, as a result of which there is nothing much that the United Nations or the Security Council can do, even when you see complete violation of international law, which we are seeing, that what Israel is doing to Gaza and what the US and Israel have now done to Iran. But in the US, for example, of course the US was a country. It's also a bit unfortunate in my view that we have the world divided into sovereign countries where each country says that it is sovereign and it can decide do whatever it wants. And virtually, most of or many of these countries do not follow any norms of international law. And this is the result of the world being divided into many sovereign countries, where each country feels that it is sovereign to do whatever it wants. But the main idea of federal structure actually is derived from the American Constitution. In America, in the US, you had a new country which was created. They created their own constitution. And that country was divided into many states. And each state was given certain powers which they can do on their own. In the United States Constitution, the states have more powers than under the Indian Constitution. The Indian Constitution is also regarded by many people as a quasi-federal, half-federal constitution, where see, the basic principle of federalism should be that those issues which involve only, let's say, one district should be decided in that district. Only those issues which involve many districts should go up higher to a state. Those issues which involve many states, only those issues should go higher to the central government or the central legislature, wherever. But under the Indian Constitution, that was not done by way of federalism when the Constitution devolved powers to the states. And from the time that the Constitution was written till now, things have, instead of becoming better, in fact, one would have expected that over the years, because when the Constitution was first written when India became independent, there was a fear that because this country consisted of many languages, people speaking different languages, professing different faiths, many at that time were still princely states at that time when independence was achieved and the constitution was written. And therefore there was a fear that if you allow too much power to the states, the country may disintegrate. But over the years, we should have expected that more powers will be devolved to the states and to the local bodies so that it becomes a truly federal structure. But instead we are seeing that the opposite has happened. So why do I say that we had a quasi-federal structure to begin with? It's because firstly, residual powers under so the constitution has three lists: the union list, the state list and the concurrent list. Union list, the power to make laws on those subjects are with the central parliament, and executive powers are also with the central government. In the state list, the powers are with the state government and executive with the state legislature and executive powers with the state governments. In the concurrent list, the power to make laws are with both the parliament and the state legislature. But the constitution further provides that if there is any conflict between the laws made by parliament on those subjects in the concurrent list and the laws made by the states, the laws made by parliament will prevail over the laws made by the states. And there is a residuary entry, and that residuary entry is in the union list. It says any other subject which is not provided for in any of the lists, that power will be with the union parliament. So therefore, to begin with, we gave residual powers to the union parliament, and we gave overriding power even on matters in the concurrent list to the union parliament, to the central parliament, that those laws will prevail over the state-made laws, even when the subject is in the concurrent list. But even more than that were the financial powers. You see, ultimately, the power of any government to do what it wants to do by way of executive action also is dependent upon how much finances does it have under its control. And the powers of taxation were, to begin with, divided in a way such that most of the powers of taxation, or at least the main powers of taxation, and therefore the power to raise funds, were with the union parliament and the union government, central parliament and the central government. And only some relatively minor powers of taxation, and therefore the power to raise money, were with the state legislatures. And that problem has been further compounded now with this GST. Earlier, at least, the power to levy sales tax, etc., and therefore the revenue coming from sales tax was with the state governments. That was one of their most important means of raising funds. Now that has also gone because you now have a GST, and GST is administered by the center, and in that some part of the GST which is collected is supposed to be given by the center to the states. But to begin with, the financial system or the financial powers that were there, as I said, since most of the powers to levy taxes, that is income tax, all kinds of income tax, direct income tax, corporation tax, excise duty, customs duty, these were all with the center, and these are the main ways of raising funds. So there is a system of a finance commission which is supposed to be independent of the center and the state, somewhat independent, which then decides how much funds will be given from the center to the states. This itself shows you that the power of funds is very uneven, heavily biased towards the center, because that is why they have to give funds to the states. And over the years, the independence of the Finance Commission has also been called into question. And over the years, thank you. I'm sorry, I have a bad cough and cold, unfortunately. So, over the years, people have started questioning the independence of the Finance Commission from the central government. And finance commissions are also seen to be doing what the central government wants them to do. And that is why you have this situation which is quite remarkable, that when the Prime Minister campaigns for elections in a state, they say that elect a BJP government so that you will have a double engine government in the center and the state. If you have a double engine government, your government will get more money. If you elect a government of the states, then you will get less money. They openly say this, though this is totally contrary to the principles on which funds should be devolved to the states. It should be completely independent of who is in power in the states. That decision has to be made on some objective considerations. But unfortunately, that is not so. On top of that, you have the power with the central government, with the governors who are also appointed by the central government. Today we have a system where governors in the states are appointed by the central government. They serve at the will of the central government. That means they can be removed whenever the central government wants to remove them. They can be replaced by whoever else. With the result that these governors who were supposed to be independent authorities have also become tools in the hands of the central government. And governors have some important powers. Of course, first is the power to decide who to call to form the government after an election. The governor decides who to call to form the government, and when you have a situation where nobody has got a majority, the governor has a lot of discretion, and usually we have seen in the recent past that these governors have acted as just agents of the central government. So they will decide who to call, who not to call, depending upon the instructions that they receive from the central government. Then the second power is to recommend president's rule. If they feel that the government of a state cannot be carried on in accordance with the constitution, that's a very wide power. Then they can recommend president's rule, and the center can impose precedent's rule. That's also a reason to feel that the states are gradually being strangulated. The powers of the states are strangulated by one after another methods. And then third is the power of governors to sign the laws passed by the states. What happened in Tamil Nadu in that case, some of you may be aware of, that in Tamil Nadu, of course, that is not confined to Tamil Nadu, it is common in all the opposition ruled states where governors routinely refuse to sign laws passed by the states if the central government doesn't like those laws. And therefore they just sit on those laws for months, sometimes for years altogether. And until they sign, it doesn't become law. So that is why the Supreme Court, in that important judgment about a year and a half back, gave a very important judgment saying that, look, this kind of situation cannot be allowed to continue. And therefore, if a governor doesn't respond within 3 months, governor has the power to send the bill back for reconsideration. But after it is reconsidered and reiterated, he has to sign it. But they are just sitting on it. So the Supreme Court said that if the governor doesn't respond in 3 months, then it will be deemed to be an assent by the governor and the bill will automatically become law. Notification will have to be issued, it will automatically become law. That's a perfectly correct and sound decision of the Supreme Court. Unfortunately, because the central government didn't like this, they made a presidential reference to the Supreme Court, framed some questions around that only. Constitution bench of the Supreme Court heard it for many days and they have reserved judgment. We don't know whether they will overrule that excellent judgment or not. And this situation is the same in a way of what is happening in the judiciary also. One of the ways in which the government has controlled the judiciary or influenced the judiciary and reduced the independence of the judiciary is by just not allowing the appointment of independent judges. The law is that judges are selected by a collegium of 5 senior judges of the Supreme Court. Thereafter, the central government has one power, that if they don't like any particular names in that selectees, they can send those names back to the collegium with their objections. If thereafter the collegium unanimously reiterates those names, then they have to be appointed, much like the case of governors dealing with bills passed by the state legislature. But what the central government or this present central government has been doing is that when they don't like a name recommended by the collegium, they just sit on those names without saying yes or no, much like what the governors have been doing. They just sit on it, don't say yes or no. If some Chief Justice pushes the government that, look, either say yes or say no, you can't sit on it for so long, then even when the central government says no and sends back the recommendation with objections, and thereafter the collegium unanimously reiterates those names, the central government has still not been appointing those judges and just continues to sit on those names. There have been dozens of such cases. And this is how the central government or this central government has been frustrating the appointment of several independent judges which have been recommended by the collegium. Of course, in this situation, the Supreme Court should have done exactly what they did in the governor's case. They should have said that if the central government doesn't respond in 3 months, it will be a deemed assent, and that judge will automatically be administered oath and will be appointed a judge. But unfortunately, the Supreme Court hasn't been able to gather enough courage to say that. So there are many examples which will show you why power has tilted more and more and more towards the central government. Of course, the present government says we will have one nation, one election, we will have one nation, one language. They are trying to make it more and more centralized. One nation, one election also means that the state legislatures are literally just following the elections of the parliament, and even if the state government falls mid-term, then it will just continue under president's rule or under a caretaker government for the rest of the term until elections are to be held in parliament. I mean, it's an absurd thing. It makes a mockery of our democracy. But this is what this central government is trying to do. Even the legislative change that they have made to Manrega, the Mahatma Gandhi Rural Employment Guarantee Act, you see, the law was that one person from every rural family is guaranteed at least 100 days of employment at least minimum wages. That's the law. Of course, this government had not been allocating enough funds for Manrega, with the result that on an average people were getting employment only for 50 days instead of 100 days. But now they have replaced this act by a new act which says that the central government will decide how much budget there is to be given to this. Earlier, that central government had no such discretion. They had to provide as much budget was required to guarantee those 100 days of employment to at least one member of every rural family. Now, with the new law, they have given themselves the power to decide the budget and decide the budget state by state. And they keep saying the same thing, that if there is a double engine government, that state will be given more funds. If the state is under an opposition government, that state will be given less funds. Unfortunately, this is what they have been saying. Now, recently, you may have seen that Justice Kurian Joseph, who is also, I believe, from this university, was appointed in charge by the Tamil Nadu government as to chair a committee to recommend what changes need to be made in our constitution, in our laws, to strengthen the federal structure. They have given a very good, very important report, that committee, and they have given 11 arguments or 11 reasons why federalism needs to be strengthened, that more powers need to be given to the states than which are existing currently. So the first argument they say is the liberty argument. They say that why divided power safeguards freedoms. Then the second argument is the strategic focus argument. Why over-centralization weakens governance. The third argument they say is the democracy argument. Why subsidiarity strengthens accountability. Fourth argument is the resilience argument. Why centralized systems fail under stress. Then the innovation argument. Why decentralization fosters experimentation. The social justice argument. Why social reform emerges from the states. The probity argument. Why dispersed authority promotes integrity. The incapacity fallacy. Why central distrust produces state weakness. The control fallacy. Why coordination outperforms command. The equalization fallacy. Why centralization breeds dependency. The uniformity fallacy. Why diversity sustains federal unity. You see, this view, today one of the things that this government keeps saying, the central government keeps saying, is that we want a Hindu Rashtra. What does that mean? Of course, in one way that means we should have only one religion in the country, the Hindu religion. In another way it means that those professing any other religion except Hinduism should be stripped of at least their voting rights. They should be made second-class citizens in this country. Without understanding that diversity is a strength of this country. Diversity is not a weakness of this country, it's a strength of this country. If you have people professing diverse faiths, speaking diverse languages, eating diverse food, practicing diverse culture, all those things strengthen a society rather than weaken a society. And that's another good reason why we need proper federalism and why should power be devolved, more power be devolved to the states, and from the states to the districts, from the district to the local bodies, etc. This committee, of course, one of the other things that we have seen is how this government has converted some states into union territories. Kashmir is a prime example. That they impose president's rule. To convert a state into a union territory, you need a resolution passed by that state legislature. They suspended the state legislature, imposed president's rule, and they got the assent of the governor, and they converted it into union territory, saying that because there is a president's rule, therefore the assent of the governor amounts to assent of the state assembly, and therefore this is fine. So this committee has made several important recommendations, apart from generally saying why federalism is good for all these reasons, all the arguments that they have mentioned. Some of the other things that they have said is that this power of delimitation of constituencies which are there with the central government, not just delimitation. You see, today the elections of even the state legislatures are controlled by the Election Commission of India, not by the State Election Commission. And the Election Commission of India, as we have seen, is a body which is totally controlled by the central government. They are not independent at all. It was thought that the Election Commission of India would be independent. Supreme Court recently in a Constitution bench judgment said that the lack of independence of the Election Commission has been due to the fact that the central government alone has been selecting the Election Commission, and therefore the selection should not be with the central government alone, it should be with a body, with a selection committee consisting of Prime Minister, Leader of Opposition and the Chief Justice of India. But immediately after the judgment, the government brought a law which said that no, There is no need for the Chief Justice of India. It will be the Prime Minister, another minister, and the leader of opposition. With the result that again selection has come in the hand of the central government, and they have been appointing their lackeys, whoever they feel will blindly toe the line of the central government. So, with the election commission being under the control of the central government, with the state elections also under the control of the election commission, they have now embarked on this very, very absurd exercise of special intensive revision of the electoral rolls of the voters list. For the first time in the history of our democracy, the election commission is drawing up voters lists de novo. Never after 1951 have the voters list been drawn from scratch. In fact, the law says that the election commission can order a special intensive revision in a constituency or a part of a constituency for reasons to be recorded in writing. That means a fresh voters list can only be prepared in a constituency or a part of a constituency for very drastic reasons which should be recorded in writing. But unfortunately, this Election Commission of India has ordered en masse special intensive revision, which means drawing up a fresh voters list, which has nothing to do with the earlier voters list, in which they say that people have to fill up enumeration forms, people have to attach various documents to those forms, etc. Otherwise, your name will not be there in the list. Earlier, when intensive revision was done, the earlier list was not discarded in the manner in which it is being discarded today. They used to go house to house, take the old voters list, and they used to do a house to house enumeration. Nobody had to fill up an enumeration form. And there is also a provision of what is called booth sabha. That means you issue an advertisement, call all the voters of a particular polling booth, and read out the names from the old list one by one. And people will say that this person is dead, this person has moved out, this person is not here, etc. And on that basis, you prepare a new voters list. But that is also not being done. And then they say that people who are left out, etc., from the draft roll, they can fill Form 6, or if there is somebody who wants a name to be deleted, he can fill up Form 7. But though the rules provide that the election commission has to put out the details of those who have filled Form 6 or Form 7 on a website, public website, they are not doing that. Even the voters' lists are not being given in a machine-readable manner. So therefore, there is now arbitrary power now virtually vested in the election commission to add any name, delete any name, and there is no transparency in this process. So this is also another manner in which federalism is being gradually strangled in this country. And then there is this delimitation which will happen soon. Delimitation, they are saying that we need to now rationalize the seats so that every seat has roughly an equivalent number of voters. Because over the years what has happened is, because the number of seats allocated to each state has remained constant and the population growth in the states has been uneven, so the number of voters in each constituency varies considerably from state to state. That's a fair argument. But the manner in which the delimitation will be done, which means the manner in which you decide which parts of a constituency come within a constituency, or which parts of the country fall within constituency A and which parts fall in constituency B. That is also decided by this delimitation commission, which is also controlled by the central government. This is a very, very drastic and wide power, which if misused can be used to, so you can see, okay, these, in this particular constituency, our party doesn't win. So let us add those parts of another constituency to this, where people don't vote for us, so where Muslims live, where Christians live, etc. Let us add those so that this seat we will lose, but at least other seats we will win, because these Muslims and Christians will go out from those other seats. So therefore delimitation is also a very drastic power which is vested with the central government, which should not be with the central government in a federal structure. Education is another problem. You see, education used to be earlier in the state list. Thereafter it was put in the concurrent list. And in the concurrent list now, central government has the power to decide what kind of curriculum, that remove Mughal history, remove Darwin's theory, remove periodic table, etc. And because it's in the concurrent list, the central directive in a way prevails over the state. So therefore they are able to do all this. So again, the Kurian-Joseph Committee, Justice Kurian-Joseph Committee has recommended that education should be brought back to the state list. There are many other such salutary recommendations in Justice Kurian-Joseph's report. All of you, that report is, I think, now in the public domain. So all of you should read that report. It makes a very impressive case for decentralizing power to the states and for making many changes which are required to make India into a truly federal country. So thank you very much.
Thank you, Sri Prashant Bhushan, Senior Advocate, Supreme Court of India.